Today, we will discuss the important legal requirements for purchasing assets out of bankruptcy. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. Though, as we shall see, bankruptcy law is primarily concerned with federal statutory law, but I'm getting ahead of myself. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at the university level and hold 4 degrees, including 2 law degrees and a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. When purchasing assets from a bankruptcy estate, it is crucial to understand the intricacies involved in the transaction. Bankruptcy asset sales provide a unique opportunity to potentially acquire assets at reduced prices, but they also come with specific legal requirements and considerations. These transactions are typically governed by the United States Bankruptcy Code, which is Title 11 of the U.S. Code, which outlines the procedures and protections for buyers, sellers, and other interested parties. Under Title 11 of the U.S. Code, Section 363, the bankruptcy court oversees the sale of assets, ensuring that the transaction is conducted fairly and transparency, or I should say with transparency. Buyers need to be aware that such sales are subject to court approval. Therefore, it is not carte blanche, and any interested party can object to the sale during the process. This legal framework aims to maximize the value of the debtor's estate for the benefit of creditors while providing a level of protection for the buyer from subsequent claims. It is imperative for buyers who undergo the 363 process to conduct thorough due diligence before proceeding with a purchase of assets. This involves reviewing the court filings, sale motions, and any objections from creditors or other interested parties. Engaging experienced bankruptcy counsel can help navigate this complex process and identify potential risks associated with the acquisition. The bankruptcy court plays a pivotal role in asset sales in the context of bankruptcy, ensuring that the process aligns with the strict legal standards set forth by the Bankruptcy Code. The court must approve any sale of assets, and this approval is not automatic. The debtor, acting as the seller, typically files a motion with the court to approve the sale, which includes details such as the assets to be sold, the proposed buyer, and the particulars of the proposed sale. Interested parties, including creditors, have the right to object to the sale during the court proceedings. These objections might concern the sale price, the fairness of the process, or issues with the proposed buyer. The court will then evaluate these objections and make a determination based upon the best interest of the estate as a whole and its creditors. Buyers should be prepared for the possibility of objections and be ready to address them promptly in court through counsel. Once the court approves the sale, the buyer receives a court order confirming the purchase. This order is crucial as it typically protects the buyer from future claims against the purchased assets, providing a level of finality and security, which is obviously very desirable in this context. However, it is essential to remember that this protection is not absolute and may be subject to appeal on other legal bases. Conducting comprehensive due diligence is a critical step in purchasing assets from a bankruptcy estate. I cannot repeat this too frequently. This process involves evaluating the asset's value, the condition of the assets, any existing liens upon the assets, and any potential liabilities associated with the purchase. Buyers should review all relevant documents, including the bankruptcy petition, public records, schedules, and statements filed by the debtor, as well as other interested parties. Engaging with competent and experienced professionals at the outset, such as accountants, appraisers, and bankruptcy attorneys, can provide valuable insights and help mitigate the risk profile. These experts can assist in assessing the financial health of the debtor, the legitimacy of the asset title, that's a big one, and any potential tax implications arising from or relating to the transaction. Additionally, understanding the debtor's business operations and market conditions can help inform the buyer's decision-making process and lead to a better, more informed outcome. For instance, if the assets include real estate, as they often do, buyers should conduct environmental site assessments at least phase one and title searches to identify any hidden liabilities. Similarly, if the purchase involves intellectual property, it is essential to verify ownership and any existing licensing or use agreements. These steps help ensure that the buyer is fully informed and prepared to proceed with the acquisition on fair terms. One of the most attractive aspects of purchasing assets out of bankruptcy is the possibility of acquiring them free and clear of liens and encumbrances. Under Title 11 of the U.S. Code, Section 363, Subpart F, the bankruptcy court may authorize the sale of assets free of pre-existing interests if certain conditions are met. This provision aims to enhance the value of the assets by removing any encumbrances that might otherwise deter potential buyers. To qualify for a free and clear sale, the debtor must demonstrate that one of the statutory conditions is satisfied, such as the consent of lien holders, a bona fide dispute regarding the interest, or that the interest is otherwise subject to 363 treatment. Buyers should confirm with their legal counsel that the sale terms include this provision and that the court explicitly states that the assets are being sold free and clear. However, it is essential to understand that not all sales will automatically qualify for this preferred treatment. Buyers therefore must carefully examine the sale order and consult with their counsel to ensure that there are no unresolved issues that could affect the clarity or desirability of holding title post-purchase. Despite the potential benefits, purchasing assets from a bankruptcy estate can present several challenges. Buyers must navigate legal complexities and nuances and be prepared for potential disputes with creditors or other interested parties. Therefore, it is crucial to be aware of the overall legal framework governing these transactions and the rights of all parties involved. One potential challenge is the possibility of appeals or litigation following the sale. Even after court approval, creditors or other parties may, in certain cases, seek to challenge or enjoin the sale, resulting in delays and additional legal expense. Buyers should factor this risk into their decision-making process and seek competent legal advice early in the process to understand the potential implications. Moreover, buyers need to consistently be mindful of successor liability where the buyer might inadvertently inherit liabilities associated with the debtor's pre-bankruptcy activities. While a free and clear sale offers some protection, it is not an absolute shield against all possible claims. Conducting thorough due diligence and obtaining appropriate legal counsel can help mitigate these risks and ensure a smoother transaction. In conclusion, purchasing assets out of bankruptcy using the 363 process, as it is sometimes known, can be a strategically advantageous move for buyers seeking to acquire valuable resources at potentially favorable prices. However, the legal requirements and potential risks involved necessitate a well-informed and strategic approach. This is not the time to try the do-it-yourself approach. Engaging experienced legal and financial professionals early in the process is critical to navigating the complexities of bankruptcy asset sales and ensuring compliance with all applicable law. By understanding the role of the bankruptcy court, conducting comprehensive due diligence, and recognizing the potential downstream challenges, buyers can better position themselves to capitalize on these opportunities. It is essential to remain vigilant and proactive throughout the process, ensuring that all legal requirements are consistently and timely met, and that the acquisition aligns with the buyer's overall business and financial objectives. For further reading on bankruptcy asset sales, consider exploring resources provided by the American Bankruptcy Institute, the American Bankruptcy Institute, there we go, or visiting my firm website. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.